Hi, this is Troy Hunt, and welcome to the GDPR attack plan. The General Data Protection Regulation is a really important piece of legislation that's coming into effect for the EU in 2018. But the impact of GDPR goes well beyond just the EU as well. And in this course, you're going to hear what you need to know about that impending regulation and how to get yourself ready for its arrival. Very briefly about me before we continue, I am Troy Hunt. I'm a trainer, speaker, and security specialist who helps organizations around the world secure their assets and protect their customers. You can find me on Twitter at Troy Hunt or via my website, which is troyhunt.com. But that's enough about me. Let's jump in and start taking a look at what GDPR really means. What you're seeing here is billions and billions of breached personal data records represented on the informationisbeautiful.net website. And this represents a huge amount of personal data that's been compromised out of online systems. It's a staggeringly large amount of information, and it has a huge impact on both corporations and individuals alike. But GDPR is very much about protecting the data of the people. So let's go and have a look at what this means for individuals who have their data compromised in the likes of incidents like these. Think about the impact of personal data being disclosed, misappropriated, and then reused in ways it was never intended to be. So for example, think about the impact of fraud. It can be enormously costly to individuals when their personal information is used by a malicious party to, say, log into their Amazon account. The attacker may then buy goods under their identity. Now, that can be very costly, obviously, to the victim. It leaves them with quite a mess to clean up, as well as being a serious invasion of privacy. Something like their Amazon account has their purchasing history in it. So fraud such as that can have both a monetary and an emotional cost. Identity theft is another thing that we're becoming increasingly wary of. So this is an attacker impersonating the victim to do anything from lodging a fake tax return through to taking out a loan on their behalf. You can imagine the sort of impact that can have on the victim. Yet another fallout of personal data disclosure is blackmail. The Ashley Madison data breach of 2015 is a perfect example, where members of that website received massive amounts of automated blackmail messages from malicious parties who got their hands on the data. Some people literally killed themselves over the fallout of this event. So that's a really serious example of just how much impact the disclosure of personal data can have on individuals. We have to do a better job of stemming the flood of these incidents. We have to do a better job of protecting personal data. And this is one of the most important objectives of GDPR. Now, speaking of GDPR, here's what we need to get ready for. 25th of May, 2018. If you're doing business in the EU, then this is what you need to prepare for. And in this course, we're going to go through and talk about what you need to do to prepare, and indeed what doing business in the EU actually even means. But just to be really clear about the scope of GDPR, let's take a quick look at just how significant the EU is on the world scale. At present, there are 28 member states of the EU, and that's comprised of around about 508 million people, so about 1.5 times the size of the US. They have a GDP of over 15 trillion euro, which is actually just a little bit less than the US, but it is a significantly important market on the global scale. And the significance to GDPR is that if companies are doing business in the EU and they want to be part of that GDP and of that 508 million person audience, then they need to understand the regulation, and it may well have some impact on the way they do business. Of course, this map and these figures will also be changing a bit in the coming years due to Brexit, the UK's exit from the EU, and I'll talk a little bit more about the impact of that as we progress through the course. The important thing for now, though, is that even though the EU geographically occupies this one part of the world, you need to start thinking about GDPR impacting everyone. Because in one way or another, and due to the global nature of the internet, that's what it's going to do. Now, a lot of people are looking at GDPR and thinking it's something new, and parts of it are new. But another way of looking at GDPR is that it's a simplification of existing laws. Let me show you what I mean. In many ways, GDPR is actually an evolution of DPD. So this was the Data Protection Directive. And I want to talk a little bit about what's changing in that transition from DPD to GDPR. Now, the first thing with DPD is it dates all the way back to 1995. Now, that was the year that I first got on the internet, so it dates back a very long way. And when you think about what the world looked like then, in terms of connectivity, the way we collect data, the way we share it around the world, it is now a very, very different time. So we need a more modern implementation of the way we protect individuals' data. One of the things about the DPD was that each EU country had to implement it into their own national laws. And inevitably, what this meant was that there was a lot of inconsistency. There wasn't this singular standard view of the way data is handled. This made things quite tricky for organisations operating in the EU across multiple markets, which is a very normal thing for organisations in that part of the world to do. And you've got a lot of different countries, a lot of different EU member states within a very short geographical distance of each other. This also made enforcement very tricky. If there's a company operating across multiple different countries within that one confined geographical space, you'd end up with situations such as different countries taking different views of personal data, different views of penalties. This made compliance quite tricky. Now, as we move into GDPR, everything starts to consolidate. So one example of that is a much broader, more consistent definition of personal data. And that's a concept we'll spend quite a bit of time looking at in this course, because GDPR does really center around this concept of protecting an individual's personal data. Now, that broader definition means that all sorts of other personal data attributes are included, and that may actually make compliance a bit trickier in some cases. So we will spend a bunch of time looking at that definition. GDPR creates a much more uniform law across those 28 member states. So where in the past, under DPD, each country could adopt, say, their own different data breach notification laws, that gets unified under GDPR. GDPR also brings much harsher penalties, and certainly this is one of the headlines that's making the news. Now, frankly, we need much harsher penalties, and I'm going to explain why as we progress through the course. And that's also one of the reasons why you really want to understand this regulation, because the cost of infringing it once GDPR lands can be significant. Under DPD, penalties were left to each member state, and often those fines were small or rarely applied. GDPR is promising to be quite different in both those regards. Now, whilst there's a lot of things to get to grips with when it comes to understanding GDPR, there's one really simple sentiment which pervades across most of what we're going to look at in this course. And it's this. This is one of the best ways I've heard of describing the regulation. And as we go through the course, I'm going to keep drawing back to this. And when you look at what the EU is trying to do, you can't help but say, Well, yes, that is actually common sense. So keep this in mind as we go through the course, and by the end of it, you'll have a much better understanding of GDPR and hopefully agree that much of it is just common sense. Let's dive into it and start taking a close look at what it means. And I want to begin with understanding the roles of GDPR. As we progress through this course, I'm going to be talking about a number of roles that play a very important part of the regulation. So I want to define those up front and be very clear about what they are. Here are 5 different roles that are an essential part of the regulation. Let's start with the data subject. And the data subject is what's referred to as a natural person. So basically, it's someone like you or I. And for the scope of GDPR, we're talking about someone who is a citizen or resident of an EU member state. So really, we're talking about the people of the EU. And the people are considered the rightful owner of their personal data. Now, this is a really important point, and we're going to talk about this in much more detail later on. But a cornerstone of GDPR is the concept that the owner of the data is the person. Certainly, many organizations like to think it is their data, but not under GDPR. It is the data subject's data. We'll come back to that a little bit later on. Next up is the data controller. And the data controller is the organization that collects the data from EU citizens or residents, so from the data subjects. One of the key roles of the data controller is determining the purposes, condition, and means of processing for that personal data. And really, this is what the organization collecting individuals' data does anyway. GDPR just formalizes that title a little bit further. Now, the data controller also had obligations under that old data protection directive model. So in many ways, there's not really a change here. However, there is a new obligation under GDPR that we didn't have under the old directive, and it relates to this role: the data processor. Now, the data processor is the organization that processes data on behalf of the data controller. So, for example, this could be a service, such as a cloud provider. Obviously, even under the old DPD model, we had services like cloud providers. We had data processors. But what changes under GDPR is that now the data processor has a direct statutory obligation. Now, what this means is that they may be subject to enforcement by supervisory authorities as well as the data controller. Previously, it was just the data controller that came under DPD enforcement. Now it includes the data processor as well. So entities doing data processing on behalf of controllers need to be GDPR compliant. Next up is the Data Protection Officer, and you'll often see this referred to as a DPO. Now, a DPO is appointed directly by a company engaged in, and GDPR's term here is regular and systematic monitoring of individuals on a large scale. Now, a DPO may be an employee or it may be an external service. But the important thing about that role is that it works independently to ensure that the entity is adhering to GDPR regulations. So this is really important. They're the one keeping the entity in check, making sure that they're implementing GDPR in the way that it's meant to be. One important thing about this role is that if an organization doesn't appoint one, yet does require one under the GDPR criteria, they may be subject to a penalty. Now, that criteria is important, and I mentioned here in the first bullet, regular and systematic monitoring of individuals on a large scale. A DPO is also required if an entity is dealing with special categories of data. So, for example, data relating to criminal convictions and offences. Those special categories may also include data about racial or ethnic origin, political opinions, religious or philosophical beliefs. We're going to talk more about some of these special classes of data a little bit later on. Important point for now, though, is that a DPO is not always required. There is a criteria which, when met, means that one must be appointed. Now, last thing on the DPO is that because GDPR does extend beyond just EU companies, an organisation outside those 28 member states may still need one. And we'll talk about the criteria for that a little bit later on. Just as a side note as well, the role of a DPO has been an essential element in the German data protection system since 1977. In fact, many companies have been required to appoint an independent DPO to fulfill their self-regulation obligations. So this is not an entirely new concept, but again, it's just a part of the EU which is now becoming standardized across the member states. Lastly is the Data Protection Authority. And here we're talking about a national authority who's tasked with implementing GDPR. Now, each EU member state is required to appoint one, at least one, and they are the ones who have the enforcement powers. Now, those enforcement powers do include the ability to issue fines, and I'll talk more about those a little bit later on in the course. Now, because the DPA is implemented at the member state level, we may still have a case where organisations operating across the EU need to interact with multiple DPAs. That should be a lot easier than under the old DPD directive because GDPR is applied so consistently, but it may still mean interacting with a number of different data protection authorities. So that's the different roles of GDPR covered. Let's move on to the real heart of the regulation, and that's personal data. GDPR is really focused on protecting personal data, and arguably that's the single most important part of the regulation. So let's start by actually defining what we mean when we use that term. Personal data is any information relating to the data subject. It's not just data about the data subject. It could also be other data owned by the individual. This term actually encompasses a number of different things. So let's drill down further and look at exactly what is encompassed under this banner of personal data. Personal data is actually a fairly broad category, and under that there's a few subcategories we need to understand. Let's look at the types of data that fit within these. And we'll start with that broad one, the broad categorization of personal data. So for example, someone's name is personal data. That's probably pretty obvious. Their birth date, their physical address, so for example, where they live. But there are other attributes of personal data that you may not immediately think of as well. So things like a mobile device ID. A MAC address on a smartphone, for example, is personal data. It is owned by the individual, and indeed it could also identify the individual. We'll come back to identifiable data a little bit later. Social media posts are personal data. The individual owns these as well. It's their data, not the data of the organisation they're giving it to. Same again with photographs. If a data subject takes a photo and puts it on an online service, it's still their photo. A new one for the modern era is the Internet of Things. If you have an IoT thing collect data, it's still your data. It's still personal data. And that's a particularly significant one today, given how many IoT things we have in our lives. If your connected fridge collects data and sends it to the internet, it is personal data. Now, a subset of personal data is sensitive personal data. And here we're talking about things like the data subject's race, what their ethnicity is, their sexuality and their sex life, philosophical beliefs. I just covered a number of these in the section on when you need a DPO. Trade union memberships is also sensitive personal data, as is information about the data subject's health. It's also possible that attributes of personal data that you see on the left of the screen could become sensitive. So, for example, there are some IoT devices that collect information about, well, very intimate parts of an adult's lifestyle. That may well then fall under the sexuality and sex life attributes of sensitive personal data. And when you think about it, it comes back to that point about common sense. Well, yes, there are devices out there that collect some rather sensitive information. Now, this is important because GDPR does have different requirements for sensitive personal data than what it does for the broader category of personal data. And I just mentioned one of those, which was the appointment of the DPO. But there's another subcategory of personal data as well, and it's genetic and biometric data. So, for example, an individual's gene sequence, which is a very specific class of biometric data. Fingerprints is one that is a little bit more common. Facial recognition is becoming a lot more common. Retina scans. All of these attributes of personal data are genetic and biometric data, and these again can have different requirements under the regulation. The important thing to remember with GDPR, as we look at all the personal data on the screen here, is that it brings a consistent view of it across all of those member states of the EU. And it gets us away from this country-by-country view that we used to have under the old DPD. Equally important is that there are other parts of the world that have different definitions of what personal data is. But if they're doing business in the EU, then they're going to need to understand this definition and adhere to GDPR regulations. I'll talk more about the criteria for that a little bit later on. Now, while we're here, just in case you're looking at this and saying, well, isn't this PII? Isn't this personally identifiable information? Let's just be clear about one thing. These are not the same. Personal data is not the same as PII. PII is certainly personal data, but there is lots of other personal data which is not necessarily personally identifiable. So I just mentioned an IoT thing such as a fridge and the data it collects. Whilst that is personal data, it doesn't necessarily identify the individual. This is an important distinction because a lot of organizations are used to dealing with PII, but the definition of personal data is a lot broader than that. PII is information that can be used to identify, contact, or locate a single person, or to identify an individual in context. A photograph that someone takes of a landscape is not PII, but it is personal data. It's considered rightly theirs. So the impact of this personal data definition is very important, particularly if an organization is just thinking, well, we'll take our PII controls and we'll extend that into GDPR and we'll be fine. And it's important to recognize that even for PII, there are very different definitions of it around the world. Let me give you an example. I've heard many people have this discussion in the past. Is an IP address personal data? Well, let's start in the EU and we'll compare that to the US. So in the EU, yes, an IP address alone is personal data. Whereas in the US, it's not. It's actually considered linked PII. And unless it appears in the context of other information as well, it's not considered PII. I wanted to give this example just to illustrate how different the definitions of the same piece of data can be in different parts of the world. But if you're in the US and you want to do business in Europe, then you will need to comply with the obligations that treat an IP address alone as personal data. Now, this was also a problem under the old DPD, when each EU member state got to decide what constituted personal data. So this is a great example of the harmonization that GDPR brings to the EU. Now, if you do need to comply with GDPR, and we'll talk more about those criteria shortly, here's a great way of thinking about personal data. This really moves away from the way many organisations look at the information they collect from their own data subjects. All too frequently, there is the view that all of the data an organisation holds is their data. They own it. They can do what they want with it. Not under GDPR. The data subject themselves owns that data. And one of the key objectives of that regulation is to give citizens and residents back control of their personal data. One of the really important ways that GDPR is doing that is by enforcing consent. Let's look at what we mean by that term. Consent is one of the cornerstones of GDPR, and there are several key measures that indicate a data subject has consented to their data being made available to a data controller. So, for example, the data must be freely given. Now, what this means is that the data subject, the individual who owns the data, must be able to refuse consent. They must be able to say, no, I'm not going to give you my personal data. They must have a genuine choice not to provide the data. Now, that may also mean not partaking in the service offered by an organisation. So, for example, if a company is running a competition and the data subject says, no, I don't want to give you my contact information, then they can't exactly enter the competition. The point is that they have free choice not to. Consent must also be specific. It must be intelligible, easy to understand, and comprehensible. The controller must clearly and precisely explain the scope and the consequences of the data processing. So you can see how all of this is increasingly informing the data subject of how their data will be used. In fact, that's the next point, informed. The nature of the processing has to be explained in an easily accessible location, using clear and plain language which does not contain unfair terms. The data subject should also be aware of the identity of the data controller, and they should also be aware of the purposes for which that personal data will be processed. So really, we're saying that individuals should know who they're giving their data to and how it's going to be used. Consent must also be unambiguous. So GDPR talks about a clear affirmative action when personal data is solicited. And really, this continues the theme of the other objectives you see here, which is being clear and upfront about how personal data is going to be used. Now, at this point, it's also worth noting that not all of this is black and white. You can imagine that there'll be many shades of grey here in terms of the way organisations subject to GDPR argue whether, for example, consent was informed, or was consent actually unambiguous. These are not clear-cut definitions with singular implementations that will be the same every time. And certainly, one of the things that everyone agrees on with GDPR is that we have to wait and see how the regulators, so how the data protection authorities, actually enforce it. Because certainly, there is some subjectivity around the way we define these objectives. Now, one more thing on consent. All of this applies for the broad category of personal data. But on that last point, the one about being unambiguous, things change a little bit when we're talking about sensitive personal data. Once data is sensitive, we move from unambiguous consent to explicit consent. Now, this can sound a little bit confusing, so let's try and define the two terms. Unambiguous could be entering the competition I just described. If you go to a website and you enter a competition and you provide your data to do it, it's pretty clear why your data is needed. It's unambiguous why you're providing it. You hope that you're going to win, and then you need to be contacted. Explicit is a much more proactive action. So that is saying, for example, actually checking a box saying, yes, I agree for my data to be collected and to be used in the way described here. So unambiguous consent is very much implied. Of course you need to provide your data to enter that competition. Where explicit is a much more affirmative action. If the data being collected is sensitive, per the earlier definition, then it falls into that explicit consent requirement. But there's another twist here as well, and it relates to children. This is another good example of how the same concept can be viewed differently in different jurisdictions. So for example, in the US, there's COPPA, the Children's Online Privacy Protection Act, and that defines a child as being anyone below 13 years of age. Under GDPR, that definition is 16 years of age. And when the data subject is a child, then processing of their data is subject to consent by whoever has parental responsibility. But there's another twist here as well, because member states of the EU may independently determine that that 16-year age limit can be reduced to 13 years. Not below there, it must be somewhere between 13 and 16, but they can make that independent determination. And that's a bit of an illustration of how even under GDPR, the definitions across the EU of how personal data need to be handled can still have subtle differences. There's just one more thing I want to look at in this module on personal data. There's two important concepts I want to establish here, and the first one is right of access. Now this really comes back to the common sense component of GDPR, and in essence it says that a data subject, so the rightful owner of the data, should be able to get access to it. Now GDPR specifically says you must provide a copy of a data subject's information free of charge. And that's very important because it puts the obligation of that right of access back onto the data controller. Now GDPR does also say that you can charge a reasonable fee when a request is manifestly unfounded or excessive, particularly if it is repetitive. So obviously they're trying to implement some protections for the organisation should a data subject be unreasonable in their requests. GDPR also says that you may charge a reasonable fee to comply with requests for further copies of the same information. Now this doesn't mean that you can charge for every subsequent request, and they do say that the fee must be based on the administrative cost of providing the information. But clearly the overriding sentiment here is that people should have free access to their data, but they also shouldn't abuse the legislation in order to unfairly burden the company holding it. Another really important aspect of personal data under GDPR is the right to erasure. Now you'll often see this referred to as the right to be forgotten. Individuals have the right to take back control of their data, and this applies to a range of different situations. So for example, if the personal data is no longer necessary in relation to the purpose for which it was originally collected or processed, it should be erased. Now that should happen regardless of whether the individual asks for it to be erased or not, and I'll talk more about that later on as well. It should also be erased if the individual withdraws consent. So this is effectively them exercising their right to be forgotten. If the data is unlawfully processed, so if the processing is in breach of GDPR, it should be erased. If the individual objects to the processing and there's no overriding legitimate interest for continuing the processing, it should be erased. And the theme which pervades across the retention of data is that it should only be there for the purposes in which it was given for as long as it is needed, and then it should be removed. And that again is a very different philosophical approach to the way many organisations have handled personal data in the past. So that's how GDPR views this concept of personal data. Let's move on to one of the biggest questions that's come out of this entire regulation, and it's territorial scope. The concept of what parts of the world GDPR actually applies to is a topic that's generated a huge amount of discussion, and we refer to it as the territorial scope of GDPR. And the big question so many organisations are asking is this. There are a lot of different opinions on this. So for example, I've heard many people say that so long as your system contains data of someone who's a citizen or resident of the EU, you must adhere to GDPR. And for something as global as the internet, that concept would extend to just about everything. So we're going to take a much closer look at that throughout this module. But let's take a closer look at how GDPR defines this concept of territorial scope. This is what many people are pointing to when they say that GDPR extends to everyone. It's often referred to as extraterritoriality, and here's what it means. Even if the data controller or data process is not established in the Union, then GDPR applies to them. Now that's regardless of whether the processing takes place in the EU or not. So if you're, say, an Australian company, and you're processing the personal data of data subjects who are citizens or residents of the EU, then you come under GDPR. Now that actually has a lot of people concerned. Because what if you're just running a service that anyone on the internet may use, and some of them happen to be in the EU? Does GDPR apply to you? Well, let's drill down on this further, because this is a really pivotal discussion in the scope of GDPR. The critical nuance here, in terms of whether GDPR actually applies outside the EU, is whether or not you're offering goods or services to data subjects in EU member states. Let me give you some concrete examples that are used to illustrate whether or not that's the case. So a really easy one is if you have an EU office, you're probably targeting people in the EU. That's a pretty reasonable conclusion to make. If you're running a service that provides content in EU languages, you're probably targeting people in the EU. For example, if you can view content in Dutch, you're probably targeting people in the Netherlands, an EU member state. If you represent prices in EU currencies, you're probably also targeting people in the EU. Now remember, that doesn't just mean that you've got prices represented in euros. It could be Swedish krona, for example. Sweden is an EU member state. And if you're representing things to them in a locally relevant context, you're probably offering Swedish people goods or services, and you're probably going to be subject to GDPR. If you have domain names for your website clearly targeting people in the EU, then that's another indication that you're offering them goods or services. And that doesn't necessarily mean just .eu domains. Could be a .fr domain for France. The point is that these are all indicators that you're trying to do business in the EU. And if you want to do business in the EU, you need to adhere to GDPR regulations. Now, to be clear as well, this doesn't just apply if you're selling things to people in the EU. You could be providing a free service, but if you're clearly targeting them and implementing the sorts of behaviours that you see here on the screen, then whether they're paying for the service or not, the service likely comes under GDPR. Let me give you an example of how a government outside the EU is advising organisations on GDPR compliance. Here's some examples from the Office of the Australian Information Commissioner, the OAIC, and these are some good points that reinforce what we just saw. So for example, an Australian business with an office in the EU is likely subject to GDPR. We just covered that. an Australian business with a website that enables customers to order in a European language other than English, or enables payment in euros. We just covered that as well. And this is precisely word for word the guidance that the Australian government is giving Aussie businesses. And it's the same sort of guidance we're seeing from other governments in other parts of the world outside the EU. If the website mentions customers or users in the EU, then it's probably trying to appeal to data subjects in the EU and is likely subject to GDPR. So you can see how these same tests keep coming up again and again, and they're good ways of assessing how likely it is that GDPR applies to other parts of the world. Let's look at an example. This is StrawberryNet, and StrawberryNet is a Hong Kong-based cosmetics website. I connected to the internet in the Netherlands, and I went to my browser and I typed in strawberrynet.com, and this is the page that I then saw. So let's go through this page and have a look at how many of the criteria we just discussed are met by StrawberryNet. And the first thing that you'll notice here is the address. There is now an EU domain in that address. My browser automatically redirected me to nl.strawberrynet.com because I was connected in the Netherlands. The website is also representing the euro currency, not just up here in the top of the page, but in pricing the individual goods on the website. Whilst the website is in English, they do make particular reference to the Netherlands. And certainly there are some parts of the world where you can get the website in other languages. And finally, the website definitely does want to attract international customers because they offer free worldwide shipping. So when you look at this site, it would be very difficult not to conclude that StrawberryNet is marketing goods and services to people within an EU member state. It is extremely likely that this particular website would come under the scope of GDPR. Let's take an example of a website very unlikely to come under GDPR. Imagine I create a website that's a cat forum, Troy's Cat Forum. I'm running it in Australia. It's got a .com.au domain. And the whole idea of my cat forum is to establish what sort of cats people like. There are articles about cats for cat lovers. They can go down and register in order to discuss cats, and they will need to provide some personal data to complete that registration process. Once registered, they can post things about their cats, and it may well be people from EU member states that provide their personal data in the registration and then provide more personal data by way of actually contributing posts to the site. In short, my cat forum could end up with a lot of personal data belonging to data subjects in EU member states. But this is very highly unlikely to come under the scope of GDPR. I'm not representing content in EU languages. I'm certainly not pricing anything in euro currencies. It's not an EU domain, it's an Australian domain in this case. And I definitely don't have an EU office. This is simply a website on the internet. And anyone, anywhere in the world can come to this website and use it as I designed. And when you compare that to the StrawberryNet example that we just saw, you can see how fundamentally different the objectives are. GDPR is not setting out to put a site like this within their scope. And indeed, any sort of enforcement, even if they did, would be enormously difficult. I'm just an Aussie running a cat site, and just because people can access it from the EU doesn't put it under EU regulation. Now there's just one more thing on territorial scope, and it's this. What happens to the United Kingdom after Brexit? Well, there are two important things to keep in mind here. The first is that the UK's exit from the EU will not be completed before GDPR kicks in May 2018. So there will be a period of time where the UK is still officially part of the EU and GDPR is in effect. The second is that even once the UK does exit the EU, at the very least, they're still going to come under that territorial scope we've just been discussing throughout this module. So just like in the US or Australia or anywhere else, if organisations in the UK are promoting goods and services to people in the EU, GDPR is almost certainly going to apply to them. But of course, it is a little bit more complex in the UK because they have been a part of the EU for so long. Many organisations have existing business relationships. They have very close geographic proximity. They've worked freely across the EU for a very long time, and inevitably those relationships and those customers are very often going to prevail into a post-Brexit United Kingdom. So GDPR is going to be much more important to companies in the UK than what it is to countries in faraway parts of the world that don't have that historic relationship. So in short, GDPR is still very important to the UK, especially given the established business practices already in place. Next up, let's go and talk about when it all goes wrong. Let's talk about breaches and penalties. This is really the teeth of GDPR, the stick. So what happens when an organisation breaches their obligations under the Global Data Protection Regulation? And certainly some of the figures that we're going to discuss are the ones that have made headlines, the ones that have organisations so worried about what might happen if they don't get GDPR right. Let's start by talking about what happens if there's a breach. This is the exact wording of the regulation, and there are a few important things here. One of the first things that probably stands out to you is this 72-hour period. So if a breach of personal data happens, the data controller has got 3 days in which to report it to the supervisory authority, and that's a maximum of 3 days as well. However, the GDPR wording does also use the term where feasible. So now we're back in this space again where you can see that there's going to be scope for organisations to take perhaps some liberties in the way they implement the regulation. Now, if they can't do it within 72 hours, the report must also be accompanied by reasons for the delay. And that, again, seems like common sense. It seems quite reasonable. In fact, the whole 72-hour objective seems quite reasonable. And when you think back to all of those data breaches that I began this course with, and you consider the impact to the individuals in there when their personal data is disclosed, the obligation for the data controller to report that within 3 days seems very fair and indeed in the best interests of the data subjects. Now, if a data controller does need to make a notification, there's a few things they need to do. So they must be very clear about the nature of the personal data exposed, including the categories of data, the approximate number of data subjects concerned, and the likely consequences of the breach. They must also describe the measures taken or proposed by the data controller to address that personal breach, including any measures to mitigate the possible adverse effects. And again, all of this seems quite reasonable. Report it quickly, explain how it happened, what the impact is, and what you're doing to try and reduce the adverse impact of it. However, there is a caveat to all of this. If that breach is unlikely to result in a risk to the rights and freedoms of the natural persons involved, it doesn't need to be reported. And this actually feels very out of step with the rest of the GDPR regulation. It's the sort of thing that you could see companies arguing their way out of. So they may have a data breach, but then independently determine that it's unlikely to pose these risks. This is a bit worrying because it's more in the interest of the organisation making that determination than it is in the interest of the data subject themselves. In fact, we used to see HIPAA have a similar clause. So this is the Health Insurance Portability and Accountability Act in the US, which relates to health data. And they used to have a harm standard. So is the breach going to harm the individuals who own the data? but it was later dropped so that all breaches require notification. And that seems a much more reasonable approach, and we may well see GDPR revised in the future to reflect the same approach. But assuming it does all go wrong, and rights and freedoms of natural persons are actually impacted, what are the penalties? Because again, that's what's getting organisations really worried. Well, let's start by looking at the problem we're trying to solve when it comes to penalties for breaches. In 2015, the UK telecommunications company TalkTalk suffered a major data breach. As a result of that breach, TalkTalk was fined by the ICO. So this is the Information Commissioner's Office in the UK. And that fine amounted to £400,000. Now let's put this in perspective, because TalkTalk is a large company. In fact, TalkTalk is so large that they have revenues of almost £1.8 billion per year. Now I'm reflecting that revenue in the column on the left. It's there in turquoise. I'm reflecting the fine in the column of the right in red. Except you can't see it, because a £400,000 fine when you're earning almost £1.8 billion is absolutely nothing. Think about it like this. If you earned $100,000 a year, being fined 0.022% is like being fined $22. It's what you might spend to go out for a nice lunch. So clearly, penalties of that level are not going to provide much incentive for organisations not to have breaches. But GDPR changes this equation quite significantly. Up to €20 million or 4% of the annual worldwide turnover for the preceding financial year, whichever is greater. Now suddenly, the penalties have teeth. This is a serious amount of money. And when you put that back in the context of TalkTalk, suddenly their potential penalty under GDPR is no longer an invisible line on a graph. Now, it's £72 million. Now, would TalkTalk actually be fined that much under GDPR? Well, we don't know. We're yet to see this tested. And keeping in mind that is the maximum amount that an organisation can be fined under the regulation. The sorts of infringements that GDPR talks about that would potentially invoke that 4% include things like violating the basic principles for processing, including the conditions for consent, infringing on the data subject's rights, transferring personal data to a recipient in a third country or an international organisation, or non-compliance with an order or failure to provide access to a supervisory authority. So these are all the most egregious breaches possible of GDPR. In terms of whether it's 4% or some amount less than that, GDPR talks about different factors that will ultimately determine how large the penalty is. So, for example, the gravity and the duration of the infringement, whether it's intentional or negligent, and the actions taken by the controller to mitigate the damage suffered by the data subjects. Now again, this is an area which is grey. We're yet to see it tested. You can imagine organisations trying to argue factors such as gravity and negligence. But that 4% does remain the headline that's causing so many organisations to take GDPR much more seriously. But there are various penalties that can be levied that fall well short of 4% of your gross global revenue. Some of the other sanctions include things like smaller fines. So for example, GDPR talks about €10 million or 2% of gross worldwide turnover, again, whichever is the larger, for things like failure to fulfill the obligations of the data controller. They also say that audits may be one of the sanctions that's imposed under GDPR. If you fail to comply with the regulation, you may be subject to regular periodic data protection audits. Warnings is another option. If it's a first or non-intentional incident of non-compliance, you may just get a written warning. And that is much better than some of the other options when it comes to sanctions under GDPR. So hopefully that gives you a good sense of what non-compliance can mean to an organization. I'll finish this module with one last point. GDPR talks about penalties being effective, proportionate, and dissuasive. And at least in concept, that sounds very good. When we think back to the TalkTalk situation, that £400,000 fine is arguably none of these things. Certainly the fine from the ICO would have had very little impact on them, not particularly effective. It certainly wasn't proportionate, and again, it was equivalent to spending $22 if you earn $100,000 a year. And for a penalty that was so small, arguably it is not particularly dissuasive. GDPR is setting out to change those things. So that's penalties. Let's move on and talk about how to put GDPR principles into action. Let's talk about how we can start tying all this together. And we're going to cover some of the fundamental principles you should be applying in order to prepare for GDPR. Now, there's a really simple way of explaining the way we should be thinking about designing compliant systems, and it's this. This is a really important concept, and it underpins so much of what GDPR stands for. In fact, in the regulation, in Article 25, they say data protection by design and by default. And again, the sentiment that you should be getting throughout this course is that the objective is to always protect the data subject's data. And it's something that should be built in right from the inception of the business concept. So if you're building a system and you want to be GDPR compliant, before specs, before anything's designed or built or tested, you should be thinking about how are we going to protect the data subject's data. Let's take a look at some ways of doing that, both for new systems and existing brownfield ones. And I want to start with data minimization. This is a really important concept because it's saying that we really should only have what is adequate, relevant, and limited to what is necessary in relation to the purpose for which they are processed. So in other words, don't collect data you don't actually need. Now this is the concept of data minimization, and it is a cornerstone of GDPR. And it also speaks to that long-held security principle of you cannot lose what you do not have. From a privacy perspective, from a data protection perspective, this makes perfect sense. It's a very, very basic principle, but it also goes against the way many organizations have been operating. Let me show you what I mean by that. So often in information systems, the objective people have is to maximize the data they collect and retain. Capture everything we possibly can. That's going to give us the most options as a business. But that's not really in the best interest of the individuals. Having said that, there are a couple of key factors that have led to this data maximization behavior. And one of them is the cost of storage. It is so cheap to store data. By default, many organizations simply retain information for perpetuity. There isn't this mentality of let's get rid of the things that we no longer need. In fact, it's often more expensive to do that because the organization would then need to proactively prune the information they already hold. So cheap storage is one factor. The emergence of big data is the other. Big data has become big business. The more data we have, the more we can process, the more we can learn about our customers, tailor solutions to them, market our products. You can see why collecting and storing everything possible is very attractive to organizations. But these factors result in data maximization, which is the exact opposite of what GDPR is trying to achieve in their objective of data minimization. Let's drill down into that further and have a look at what the regulation is trying to do. When we talk about data minimization, here's some questions to ask yourself. First of all, what data do we actually need to collect? So for example, if someone signs up to your website, do you actually need their birth date? Now, some people argue that yes, we need the birth date in order to make sure that the person is old enough to use the service. And even under GDPR, we just saw the regulations about what constitutes a child. However, there's a difference between establishing whether someone is a child and actually storing their birth date. So for example, there could always be a stage gate within a process which establishes whether someone is a child or not simply by asking for the birth date. It's not that the birth date then needs to be stored for perpetuity in the system. And that's a great example of data minimization, not storing something that you don't actually need. How long the data is stored for is another really important question to ask. So do you still require it after a certain period of time? If a data subject is signing up for a competition and their consent is based on the entire premise of participating in that competition, and the competition runs and then closes, retention of the data is probably no longer necessary. If that data is deleted, then we get back to that security principle of not being able to lose what you do not have. GDPR actually clearly states that there is an obligation for the controller to erase data that's no longer needed. Where the data exists is another good question to ask yourself. How many locations does that data need to exist in? So many times we see personal data replicated throughout multiple systems within an organization. Does it really need to be in all those places? How can you minimize those copies? Because obviously once you minimize the copies of data, you reduce the chances of it being misused. Now, of course, there needs to be balance there because we need backups, we need disaster recovery. The challenge is deciding how much is sufficient and how much is excessive and moves you away from this objective of data minimization. And finally, the purpose of the data. So when you're thinking about how to become GDPR compliant, look at the data you already have and establish whether it's actually being used solely for the purpose with which the data subject provided it. Thinking back to that data maximization behavior, very often we see data obtained by an organization, provided by the data subject, the rightful owner of the data under GDPR, and yet we see it being used for something different, to promote something different or market another product. So do think about the purpose that data was provided for. Now, when you do meet all of these criteria, and you've got just the amount of data that you need, and you're using it for the right purposes, there's something else we can do to minimize the risk even further. GDPR talks about pseudo-anonymization. So this is about transforming personal data such that it can no longer be attributed back to a specific data subject, at least not without the presence of additional information. Now, on that last point, the presence of the additional information, obviously this only works if there's a breach of pseudo-anonymized data and it doesn't also include the additional information which ties it back to the data subject. So keeping that information separate obviously makes a lot of sense. GDPR is really trying to incentivize organizations to apply these pseudo-anonymization technologies because it does significantly help reduce their risk in the event of a data breach. And this makes a lot of sense when you think about it. If you have data that can't be attributed back to individuals, and just that data is breached, then there should be no impact on the individuals themselves. And again, this is the common sense component of GDPR. How can we best protect the data subjects? Let's talk about some pseudo-anonymization techniques. There are multiple different ways we can achieve this objective. And again, ultimately the goal of pseudo-anonymization is non-attribution to an identified or identifiable person. So a really good example is encryption. If data is encrypted, and it's the encrypted data that is lost, so long as the encryption key is not also lost, then the data is useless and the impact on the data subjects should be nil. Now that applies to encryption at rest and encryption in transit as well. So encryption makes a lot of sense. Another means of pseudo-anonymization is hashing. An irreversible cryptographic hash means that data can still be compared. You can compare hashes of the same input data, but you can't take that hash and unhash it. So you can't reverse it back to the original dataset. It is subject to cracking, so it's by no means perfect, but for the right classes of data, hashing can be a very effective means at protecting the underlying information. Masking is another option, and here we're talking about replacing all or parts of the data so that it's no longer legible. If a data subject's email address, for example, is appropriately masked and then disclosed, it shouldn't disclose their identity. Aggregation of data can be a really effective means of pseudo-anonymization when we're reporting on a broader collection of information. So rather than having individual records identifying data subjects, rolling it up into a non-identifiable aggregation of that data helps to protect their identity. And finally, indirect references, so pointers to the original data, and then the original data is stored separately, perhaps in a more secure location. If indirect references are disclosed, then without those reference maps, the identities of the underlying data subjects remains protected. So these are all very practical means of pseudo-anonymization that organizations can employ to reduce the risk of impact to data subjects. And when you think back to those penalties, and I mentioned some of the factors that will ultimately determine how large a fine is, one of them was actions taken by the controller to mitigate the damage suffered by the data subjects. Actions like these are very positive signs that the data controller is doing their best to protect the data of their customers. Let's look at another important action under GDPR. Record keeping. Now, this is not a particularly glamorous activity at the best of times, but it is an important part of the regulation because it provides a paper trail of how the organisation has handled and protected personal data. Let me give you some examples. When we talk about records of processing activities, we're talking about things like, who's the controller? What's their name? How do we get in touch with them? What was the purpose of the processing? So why did we have the data subjects' data in the first place? The categories of the data subjects and also the categories of the personal data itself. Is it sensitive personal data? Genetic and biometric personal data? Who are the recipients of that personal data? Either those who have already received it or those who will receive it in the future. The transfer of personal data to other countries or international organisations. So GDPR is particularly interested in how data exits those EU member states, as well as how it's managed within them. The time limits for erasure. We just spoke about data minimisation. GDPR would like to see some records on how you're going to do that as it relates to when that data will eventually be erased. And finally, and probably quite obviously, the technical and organisational security measures employed to protect the data. That's the sort of thing you want to keep documented. Now, as important as all of this is, it can also be burdensome, particularly on smaller organisations. So there is an important caveat to all this. Smaller organisations, those under 250 people, are not subject to those obligations. Now, this is great for the organisation, insofar as it obviously reduces the burden on them, but on the other hand, it does potentially put the data subjects themselves at more risk. So in some ways, this is a little bit counter to so many of the other objectives of GDPR that put the data subject first. But there's also an exception to this. There are certain criteria where, even for smaller companies, under 250 people, they still need to complete the record keeping just described. So for example, if that processing is likely to result in a risk to the rights and freedoms of data subjects. Now you can imagine how this again is one of those terms which may be open to some interpretation. So this is another area of GDPR that we need to see tested. If the processing is not occasional, if the processing includes special categories of data, and the one that's probably going to most commonly impact these smaller organisations is sensitive personal data. So if you're an organisation under 250 people and you collect, say, ethnicity or sexuality, then you're still going to need to retain those records of processing activities. Same again if it is genetic and biometric data. And really, all of this is simply saying, if there is a higher risk to the data subjects, then the organisation, regardless of their size, has to keep those records. But by the same token, a lot of this is very good practice, regardless of the organisation's size and regardless of the sensitivity of the data. Why would an organisation not want to be able to demonstrate how well it's protected its customers? And you have to think that in the case where there may be a breach and a penalty levied, and a data protection authority asks that question of what actions were taken by the controller to mitigate the damage suffered by the data subjects, record keeping of this kind would shine them in a very positive light. So that's a series of action points, things you can do to start preparing for GDPR, to put those principles into action. Let's go on and summarise the course. By now, you should have a very good understanding of what GDPR is, what the roles are, how personal data is defined, the impact of breaches and indeed what the penalties are, and how to start putting GDPR into action. Let's summarise some of those key points here. The first thing that's absolutely essential is to establish whether or not you're in scope. Does GDPR affect your business? Are you marketing goods or services to people within those EU member states? Assuming you are, understanding your data is really essential. What do you actually have? Do you know where it all is? Whose data is it? Keeping in mind that GDPR objective of the data subject owning their own data. Now, when you're clear about what you have, think about what you don't need to have. How can you exercise data minimization? Retain only that which is adequate, relevant, and limited. And that's a really valuable principle regardless of GDPR. Employ pseudo-anonymization to better protect the data that you already have. Encryption, hashing, masking, aggregation, and indirect references. Reduce the impact on the data subjects should that data be disclosed. Practice protection by design. So from the very inception of that business case, start thinking about how are you going to protect the data subject's data. So as GDPR put it, data protection by design and by default. And finally, remember that GDPR is largely just common sense. They're regulating things that we really should be doing anyway. And when you approach GDPR with that mindset, it begins to feel a lot more accessible, a lot more practical, and a lot more valuable to organizations and data subjects alike. Thank you very much for watching. This has been the GDPR Attack Plan. I'm Troy Hunt.